Hi, my name is Michael Burgess and I'm an attorney. I specialize in workers' compensation and employment law. I wanted to take a few minutes to discuss a recent change in the law, something called Senate Bill 863, and how it affects medical treatment within California workers' compensation. Prior to Senate Bill 863, the court used to have jurisdiction on medical treatment, which means if an insurance company was denying something that was reasonably medically necessary to my client, I used to be able to file a court date and go make arguments in front of a judge and get a judge to award that medical treatment. Unfortunately, with the passage of Senate Bill 863, I'm no longer able to do this, at least on the merits. Now, what happens is Senate Bill 863 has taken away the jurisdiction of the workers' comp judges to award medical treatment based upon the reasonable medical necessity. What happens now is it's governed by something called independent medical review. So let me take a few minutes to just break this down. Now, what happens in a California workers' compensation case when a claim is an accepted injury and you're treating within the defendant's medical provider network? What happens is when the doctor wants to request something, whether it be physical therapy, medication, injection, surgery, whatever it may be, that request needs to go into something called utilization review. What happens is that doctor does a request, writes a medical report, and does something called an RFA, a request for authorization of whatever the medical treatment that is needed. That RFA gets sent to the insurance company's utilization review department. This is a group of doctors that work for the insurance company, really, and what they do is they determine whether the medical treatment is authorized or denied, certified or uncertified. Now, what happens is this. When a client comes to me and says, my doctor put in a request for a specific treatment and the utilization review is denying that. Once again, I used to be able to go into court and I'm no longer able to do that. What we now need to do is then appeal that to something called IMR, Independent Medical Review. This is a complete separate system, what's called Maximus, a group of unknown doctors who we don't know who they are, what their specialty is, but they essentially review the appeal and they make a determination on whether the requested medical treatment should be accepted or denied, certified or uncertified. Now, the reason why I want to spend a few minutes to talk about this is to go over how this is done and why it's extremely important for you to have an attorney in this process. Now, you might think, well, what's the point of having an attorney if you're no longer able to go to court and argue on my behalf? Let me explain why it's very important and what the current procedures are. The utilization review determines whether something is reasonably medically necessary by looking at some medical treatment schedules or procedures. There's something called the MTUS, Medical Treatment Utilization Schedule. This is essentially a checklist of what needs to be done before something can be approved. For instance, and this is just an example, let's say somebody needs arthroscopic shoulder surgery. Before they're going to approve arthroscopic shoulder surgery, you need to show that you've exhausted a few things like conservative therapy, that you've tried physical therapy and it's not helping, that you've gotten some injections and that's not helping, and all that needs to be done before they will authorize a surgical intervention. Now, in order for this to be done correctly, the treating physician needs to understand the medical treatment utilization schedule and know how to articulate and properly request the surgery for it to get approved through utilization review. Moreover, if the utilization has denied this, you need to make sure that you have the proper medical evidence that systematically shows consistent with that medical treatment utilization schedule or some accepted means of why the treatment is medically necessary, and this needs to be done on appeal to independent medical review. Now, statistically, based on what I've seen so far, independent medical review denies 85% of their appeals. That means that independent medical review upholds 85% of the utilization review denials. Now, the problem is this, it's a few things. It's not that the medical treatment being requested isn't necessarily reasonably medically necessary. What's happening here is that the treating physician is probably not documenting it correctly, not systematically showing how and why it's needed. Now, if you have the right doctor in the beginning of the case, you won't even have to appeal it to independent medical review, because odds are utilization review is going to accept it. And if it's been denied by utilization review, you need to have an attorney that can either, one, select the right doctor who understands this and understands how to properly justify the medical treatment to get it approved, or you need to have the right attorney to win this upon appeal and attach the appropriate evidence so that independent medical review will overturn utilization review denial, and ultimately you can get the medical treatment authorized. It's also very important for you to have an attorney, because while the Workers' Comp Court no longer has jurisdiction on the reasonable medical necessity of the requested treatment, they do have jurisdiction over procedural issues. This sounds very complicated, but an easy simplification of this is sometimes the insurance company didn't timely deny it. That is, they waited too long. Let's say that the doctor who denied it didn't have the proper specialty. So there's certain procedural errors that can occur in an insurance company that gives the court jurisdiction to award the requested medical treatment. So for instance, if a doctor is requesting treatment, generally the workers' comp has 5 days to properly deny it, and it needs to be denied by a doctor with specific specialty. So these are just some things that I can look at procedurally to determine whether I can go in and have a judge award the medical treatment. Now, just to briefly summarize, Senate Bill 863 has taken away the ability for myself and all attorneys generally to argue on the merits of whether a requested treatment is reasonably medically necessary. So a judge can no longer award the medical treatment if they feel it's reasonably medically necessary. They can still award it on procedural defects. Now what happens is we have to appeal this to a company called Independent Medical Review. This is a allegedly neutral, unbiased, undisclosed group of doctors. But in order to successfully appeal it, you need to make sure you have a doctor and an attorney who knows how to properly support the justification for the medical treatment, consistent with something called medical treatment utilization schedule, and or show that there is a very good justification why the medical treatment is needed to a reasonable medical probability. So you need a very smart doctor who knows what they're doing to properly request it. You need a very bright attorney to get creative and look at the procedural defects, to look at the medical treatment utilization schedule and make sure the appeal is properly supported by the medical evidence, so that IMR can award the future medical treatment. And also, if you've been denied medical treatment, a really sharp attorney can get creative at re-requesting it, modifying it a little bit, or showing that there's a change in circumstances that warrants the current re-requesting of the denied medical treatment. Once again, in close, my name is Michael Burgess. I'm an attorney. I specialize in workers' compensation and employment law. If you have any questions on anything I've gone over with you, I know it's actually fairly complex. My office is standing by. We'd be more than willing to answer any of the questions you might have. But my one bit of advice is get an attorney. If not me, call somebody else, because you really need a sharp attorney in order to aggressively advocate for the medical treatment that you're legally entitled to.